Good morning, welcome everyone. Welcome to our special PARSEC webinar. Today we have a pleasure to organize this webinar with Southeast Asia IP SME Helpdesk and China IP SME Helpdesk. So welcome everyone and thank you very much for joining us today. Today we'll be talking about intellectual property protection in Vietnam, Thailand, Philippines, and China. It will be a pretty short webinar, but I'm sure it will be interesting to you. Just starting with a few technicalities. Today we're not having Q&A option in our platform, so please use the chat. We would like to invite you to comment and ask questions as we present, as our expert is introducing you to all the material. So feel free to comment. We will answer them on the spot or by the end of the session. In case you don't want to share any sensitive details of your business, we will share with you also the details of the contact IP helpline, so you can also contact them afterwards. At the end of our meeting today, we'll also share with you a link to satisfaction survey. So please take just a few minutes to answer a few questions about our webinar today. And as always, I would like to invite you to share the fact that you're here with us today on social media, tagging both IP Helpdesk and of course PARSEC. For those of you who are joining PARSEC webinar for the first time today, let me just give you a short intro about why are we here and who are we actually. So PARSEC is an acceleration program funded by Horizon 2020. And we started already in 2019, so we're 2 years old. And we help more than 100 companies already. Currently, we're working with 33 companies who represent 16 countries. And they're currently developing their Earth observation-based solutions for food, energy, and environment sectors. So these 15 teams developing their new solutions are helping us identify what are the needs and challenges of European SMEs. What are the things SMEs companies need to get help with to actually succeed, especially on the global market. So that's why we identified with them that IP, and especially in the phase of export, is unbelievably difficult, and really not many SMEs know how to tackle that. So that's why we're meeting today with our expert, Patrice Vidon, who will guide us through this topic. So welcome everyone once again. Feel invited to comment and ask questions. And now I will give the floor to Patrice.
Thank you very much, Veronica. Does everybody listen and hear me? Is it okay, Veronica? Excellent.
Yes, we can hear you. We can see your presentation. Yes, thank you.
Everything is perfect. Thank you very much. So as you say, Veronica, we have small time to deal with a big issue. It's big because intellectual property is key in current business relationships for companies, but also for geographical areas or for continents. There is kind of a soft battle, I wouldn't say war, but battle between America, Europe, and Asia, and of course China in terms of IP. I will touch briefly the topic of this. And so this is such a huge issue that companies can be drawn into the whole story. And you need to understand and know how to behave, what are the dangers, especially for SMEs. And our role today is to make some awareness, some beginning of sensitization to these issues. This is even more a key issue. The companies involved have to work together, so there is cooperation in your business, and as the countries we are targeting, we are studying, and especially China, are now very important countries, and even the most important countries in terms of activity and IP activity. If you don't know very much about the topic, you will be very surprised about some of the graphics I will show you. Let's have a look at what I have in mind for presenting this morning. First of all, a short presentation of myself. So I'm 61 years of age. I founded 40 years ago. Less than, no, it's not yet 40. 30 something years ago, our group. We are based in Europe with offices, most offices in France, in Brittany, west of France. But we have several offices in Asia, and now for more than 10 years, including in China and in Bangkok, Thailand. We have 40 IP consultants, and we work on all aspects of IP strategies, not only the legal issues, filing patents, filing trademarks, but how to behave, how to negotiate, how to deal with cooperation, how to deal with difficulties in having our own rights and our clients' rights respected. I have three parts. Next slide, please. Three parts for the presentation. First of all, I will present you the IP landscape. So what's going on concerning IP laws and IP activities in Far East, Far Eastern Asia, in China, and in four important countries of the ASEAN. I understand, Veronica, that I was told also to speak a little bit of Indonesia, in addition to the Philippines, Vietnam, and Thailand. And so I will touch this. And because Indonesia is such a big country, I will even take Indonesia as an example. Because of course, I will not be able to detail each of these countries and what's going on in each of these countries. So first of all, what's going on in terms of IP in these countries. Then I will show you some statistics about patenting activity in the remote sensing area. You will see that my statistics are not representative because it's not really a full study. It's just some light approach of the issue, and you will understand why. We have only selected patents that have been filed in the world, by the way, but including in Asia, by companies having the term remote sensing in their name. So of course, that's not the full stock and flow of patents filed in remote sensing, but it gives some information, even more so that in Asia, it appears that many of the companies who are working in the remote sensing have remote sensing in their name. In China, for example, you must be very explicit in your name. So you will see, and maybe you will be also surprised about the results. And then I will discuss and present some case studies and give some tips, strategical tips for SMEs who want to enter this market or want to work with these countries. So let's start with the IP landscape, intellectual property landscape in China and in Southeastern Asia, especially in the four above mentioned countries. Next slide, please. So here you have a statistics by the World Intellectual Property Office that shows what is the evolution of patent filings in the world for the past 40 years. And the first thing that must strike you, of course, is that China has become, for now more than 10 years, the leader in terms of filing of patents of invention. By far, Chinese is receiving almost three more patent applications yearly than the United States, and maybe 8 times more than the EPO. And if you look at Germany or at France, at the bottom of the graph, you will see that our national offices are not receiving quite a lot of patents compared to China. China is now, and has been now for 10 years, a predominant, is even the top actor in terms of IP. This is very important. This means that on the chessboard of IP, of claiming ownership about inventions, China is a very strong actor. There are two secondary remarks I can make. First of all, is this quantity reflecting quality in China? I'm afraid I must say yes. The quality of Chinese patent applications on average is about the same as the quality of patent applications in the United States or in Europe. When you look at the granting rate of patents, it's very similar. There are discrepancies. It depends on the domains. There are still domains where Chinese companies will file low value patent application, it's true. But in general, statistically, it's very similar. So we cannot say that, well, they have so many patents, but they are not that strong. It is not true, simply not true. Another remark, the patents application I am referring to, 1,400,000 patent applications, are filed in China. So they are valid in China only. What is so far a good news for US or European companies is that the Chinese companies do not really extend their protection into Europe or into the United States. Not yet, even though it has started already. So they protect themselves in China, but not so much in Europe and in the United States. So we are relatively safe, except for some key domains, to be relatively free of Chinese patents on our own territories. But you will understand that, on the other hand, if they are predominant on their own soil, you must be very careful when you enter that market, because they have so many patents in China that if you are an SME and you want to work in a domain, the first thing to do, and if you need to leave already now the webinar, please take this as the main recommendation. Please check what patents are relevant in your domain in China when you want to enter the Chinese market. You will hear me speak very much of China, even though I know I have to speak of Thailand, a country I know very well, because we've been in Thailand before we were in China with my group. We have an office there, have been having an office for 20 years. So we know very well about Vietnam. Okay, but the real issue, especially in your domain, I guess, is China. So I will predominantly speak about that country. Please look at what are your Chinese competitors, what they are doing in your field before you want to enter the market. Even more so that it's very likely that the Chinese actors will be active not only in China, but also in the nearby countries, including the ASEAN countries, including Vietnam, the Philippines, Indonesia, and Thailand, that are the 4 countries of interest to you today. I could speak half hour to explain the various curves and the reasons why we see these curves. You see that there is a growth, a strong growth in China that is continuing, and even though it seems to have slowed down a little bit in 2019, and of course 2020 and 2021 are not very relevant because of the crisis, so we need to see what will happen. I can bet that the exponential growth in China will continue, because a country with 1,300,000,000,000, maybe there are 400,000 now, that is so dedicated to R&D, and with such a challenge that has been increased by the current crisis, not only in China, of course, but including China, that indicates that it will continue to grow steadily. United States have been growing, but much not so quick, of course, and not so sharply than in China. Japan has been becoming stable. As you can see, there has been some modification in the law that explain that it went a little bit down. It's not really down in reality, but it's stable. And in Europe, we have really a very slow growth. We don't use the IP system as much as the Americans or the Chinese do. Let's go to the next slide, just to try to explain. If you are interested, I will not discuss that today. We don't have the time. But if you're interested to see why you have so many patent applications in China, there is obviously a correlation between the efforts in R&D, and this is the graph, you know, by the IMF, showing that's maybe 2 or 3 years ago already. So China has been jumping up, still not over the United States, but is bigger than it appears here currently. And we don't have the figures for this year. They obviously increase. So the reasons why you have the ranking in patent filing is correlated to the intensity of the R&D efforts. But what you can see is that even though China is lower in terms of R&D intensity, Chinese companies are using patents much more than United States companies, and much more than European companies. They know how to use IP. And you know what? You know why? Sun Tzu, strategy. Of course, they were not an industrial country until 30 or 40 years ago. But when they have discovered and decided to enter into the world competition in terms of industry and R&D, they immediately have got back from their culture, their ancient culture. What is strategy? And IP is about strategy. They are very, very good strategists, and they use IP as a strategy tool much more than we do. And we must be very careful because their strategies are very subtle. Even their law, the IP laws now in China, they have just modified the trademark law and the patent law for the fourth time since 40 years. They have systems I cannot discuss today, legal mechanisms that are more subtle than what we have in Europe. For example, in terms of publication, or for example, in terms of joint filing of a patent application in a utility model. I cannot do that. If I would do, Mathieu would look at me and say, well, we don't have time this morning to discuss the details. So let's stick to the big picture, because the big picture will show you that you need to enter the matter. And then to get more information, to enter into more seminars, to get more information from your outside counsels, from your association, from the IP Helpdesk, in order to understand the details. Even more so that every company has different needs. Next slide, please. So we have extracted this stock of patent applications in the world, worldwide patent applications, filed by companies under the name remote sensing. I want to make it clear, that means that the name of the company has remote sensing in it. Okay, so it's really, don't tell me again that this is not very relevant, because there are many companies who work in remote sensing, they don't have the terms remote sensing in their name, that's sure. But if you want me to make a search into the real field of activity, and not just by words, how can I say that? You need to pay me, because I need to spend quite much more time to work on that, and it's quite delicate. So we just make a first approach, and that gives some idea about what we have here. Guess what? When you just look at companies with remote sensing on the name and patent filing application, you have two lessons. One, you end up with more than 2,500 patent applications. Two, you see an exponential evolution of the number of patent applications filed. And you can see It started with almost no patents until 2000, let's say, and then very slowly and suddenly 2013, 100, 2015, 200, 2016, 300, 2017, 460, and it goes on 500 in 2018. And we don't have the figures from 2019 and 2020 because those who know already about patents, they know that patents are published only 1.5 years after they have been filed, although there can be cases where it's different. So recent figures for the 2 past years are not relevant because many of those patent applications are still secret. They are not published until 18 months. So that's why the figures for the recent years are not available. So sharp increase. So that means in your field, your competitors, the one maybe you don't even know because you don't have looked yet at the patent databases to look who is filing patents in your field, they are filing more and more patents. I hope you are one of the companies that are included in these statistics because I cannot hope because maybe your company doesn't have the name remote sensing in its name. But I hope that if I would look at all patents in the field of remote sensing, you would be in the statistics. You should be there probably if you make inventions because it seems that in your field, many companies file and file more and more. Next slide, you will see the names of the companies who file patent applications and have remote sensing in their name. And no surprise. Number 1 is RADI. RADI is quite a well-known institute in China, the Institute of Remote Sensing and Digital Earth. It's of the Chinese Academy of Sciences. So the very important and relevant institute in China, the reference institute, kind of CNRS in France, for example, or others. And they file, so I cannot really see because my face is here, but I will move it. Yeah. So they file 900, they have in stock 900 patent applications, 900 patent applications in the name of this institute. Second is the Beijing Institute of Remote Sensing Equipment. You can guess they are working closely with RADI, the number 1. Third is Aerial Photogrammetry and Remote Sensing company. It's also a Chinese company. And if you look down the 30 names, most of them, if not all of them, I've not checked the details, they are all Chinese companies. So there is a strong activity in China about filing patent applications in the field of remote sensing. My information is not scientific. It's just a guess, an approach, incomplete, but it gives some information. Do you know how many patents are filed yearly in France or in Germany? I'd say in Germany, it's about 40,000. So only 40 times more or 50 times more than the RADI. And it's and the French situation is about 1,500, sorry. So it's maybe double only that of RADI. So this institute is having an activity that is very oriented to attempting to get ownership about their invention and then to apply and then to make money in the industrial field in selling systems, devices, and so on that are related to remote sensing. I will go into more details about what some examples of those patents a bit later. So you see here who is acting in this field. Of course, there are also European actors, but you will see that there are not that many compared to the Chinese actors. Next slide. China is another world. China, if you enter the Chinese market, and in some way you will have the same atmosphere, even though that will not be as sharp as in China, in other ASEAN countries. like Indonesia, Thailand, the Philippines, or Vietnam, because of course they are very influenced by the Chinese model. Vietnam, for example, is following up very closely the Chinese model with a state that is very directive and a strategy to attract foreign investments in order to gain knowledge from foreign countries. And China has now reached a threshold where they can be more autonomous. Vietnam is taking the role of China is an alternative with lower cost, but they have the same strategy. And what is relevant to our today webinar, the same IP strategy to attract companies and to use them to improve their R&D capacities and then to patent what they have invented by themselves or jointly with others. So the IP model is very stimulating ecosystem with now President Xi, the president of China, I'd say almost every month will say that China must be even stronger in terms of R&D and in terms of patenting. And he's also personally and his government very interested in IP. They still have the image of a country that is copying. It is not true anymore. Just look at the figures. They even benefit of this image that they would be a country copying, while at the same time everybody believes that we don't have to see them as competitors. They are fierce competitors because they file patent application and they invent quite a lot, and they are now number one. And maybe they are number one in your specific field of activity, each of you SME on the webinar. In addition to this growth, in addition to this governmental strategy, there are two other factors that make it very dynamic in terms of IP. One is competition. There are so many companies, they compete so much that they use IP to gain competitive advantage much more than in other parts of the world. And everybody entering the Chinese market without being there before will be very surprised to see how much competition there is. When you have an ID, it will be copied immediately. When you have a successful company in one village, you will have 10 more companies in the same village within the coming years, because the number two, the number three, some employee of the company will think, oh, my boss is making so much money, I can do it by myself. And we'll cross the road and make it his own company, take the knowledge. And that's one of the reasons why the companies protect more, that they want to protect for employees as well. So this competition is very important. And moreover, they have an economical patriotism that makes them, even though there would be no governmental strategy, a Chinese is so proud of what the country has been doing for the past 40 years and taking some kind of, not really revenge, because they are not so aggressive, at least those I know, but at least competition. Europe has been so strong, and they have been so strong in the past 100 years, that they are so proud and so patriotic that they will work more just to support their country. And that also helps to explain why they are so active into inventing and then into protecting. I must accelerate a little bit, because after these big pictures, I want to give you some more practical information. Next slide. One curve, not totally updated for the reasons I've explained earlier. Here is the details, the breakdown of patent applications filed in China. If you break down into domestic filings and foreign filings, those familiar with IP issues, that domestic means that Chinese companies file Chinese patents. Foreign filing means foreign companies file Chinese patents. So you see that most of the filings you have here, there might be some slight difference because there is an international system that is the PCT system, Patent Cooperation Treaty. I have not the possibility to explain here today what it is. That is very helpful for small companies to get worldwide protection. That makes figures differ a little bit if you take into account PCT application or not applying to China. But all in all, For the 1,500,000, about the same figure we had 100, 400 before, you see that 95% is from Chinese companies, and only 5% is from foreign companies. Those are quicker in mathematics than me will give the exact percentage, but it's predominantly Chinese. And what is more important is that you see that the growth comes from domestic filings and not from foreign filings. Foreign filings has been relatively stable in the years. Chinese firms, Chinese companies massively invest in IPR and IPR management. Next slide, please. What I have mentioned earlier is only patents of invention. That's only one of the 3 tools to get a protection in China. There are 2 others that are not in my statistics. There are utility models and there are design patents. What you protect in a patent of invention, what you protect in Europe usually, it's the real invention. And the statistics I've compared is about product or process, I'd say standard invention on a worldwide standard, well, accepted standard. Is very comparable from one country to the other, and it offers a protection of up to 20 years. But there are other possibilities to get a protection in China, and there is the utility model. The utility model is something that exists in Germany, also the Gebrauchsmuster in German. It's another type for protecting smaller inventions, and that's relate only to the shape of the structure of the product, not the process, and it's only 10 years. This is in addition to the figures I've shown you earlier. And I have a bad news for you. There are more utility models than there are patent inventions. So if you look into the IP Chinese landscape, look also at whether there is any utility model, even more so that companies in China use utility models really as a way to try to gain competitive advantage, and sometimes in a controversial manner, I'd say. I don't say there is bad faith, but I don't say all utility models are fake. I don't say that inventions are too low to even benefit of real protection, but it can happen. So you must be very careful. Maybe utility models are not really protected, and a utility model has a great advantage that it's very cheap, and there is no examination by the patent office. The patent of invention must be granted by the patent office after examination on the grounds, on the merits. So it has some solidity. Utility models, you don't know. So that's a dangerous thing, and you need to know whether there is any utility model in your field of activity and whether it's really valid or not. But if you are ambitious, you can also consider to file utility models to protect your activity in China. And one of the specificities of China is that you can file simultaneously a utility model and an invention. This is also possible in Germany. This has been copied from the German model. And there are ways and reasons for doing that. Design patent is different, it's about aesthetical aspects. There are even more design patents than there are inventions, patent of invention or utility model. Next slide. If you look by category of patents I've mentioned, invention patents on the left, utility models in the middle, design patent on the right. The red is domestic patents, the blue is foreign patents. You will see that if there are 10% in stock, this is not the flow, this is the stock. If you have 10% of the invention patents in the hands of foreign companies, very, very few foreigners use the utility model system, and not so many use the design patent system. So because you are in this seminar, you are aware of that, and you will consider filing to protect your activity, and you will be better than your European and US competitors, but you still will have your Chinese competitors in front of you. Next slide, please. I will touch briefly what is known as the patent war between the United States and China, because everybody has heard of it. And because it was under the former US administration, some people have some political opinion on that. As a neutral, not interested in politics expert, I can tell you that there are issues that are not political and that are cultural, that the Western companies do not use the IP system exactly that the Chinese system. Who is right, who is wrong, we'll see in the long term. But you need to know that there is a way of managing economy in China, and not only in China, you can have this in Singapore, you have this in Vietnam, maybe not so much in other countries, but there are also countries with strong governments, the other ASEAN countries. They have a way to manage the economy and to make incentive to use IP that is not exactly the same we have in the West. And there is a not only governmental, but cultural and patriotic behavior of Chinese companies or Vietnamese companies or even of Thai companies or Indonesian companies that follows what is in one of the laws, recent laws there was in China, that is the National Medium and Long-Term Science and Technology Development Plan. So they have a plan to have a development in S&T, in science and technology. And what they say, what does the government, what does the law says to companies, look, you need to encourage introduction of technology from foreign countries. This is in the law. And how you do that? You introduce the technology, you digest it, you absorb it, and you re-innovate. For example, you will study how high-speed train or how aircraft have been manufactured in Europe, in Germany, in France, in Japan, in Canada, for example. Those who know the field I'm referring to will understand more about what I'm telling, and you will get to know that, and you will learn and study it, you will digest it, you will absorb it, and you will renovate. And just think what means digest, absorb, and renovate. This is really concrete steps. That means that you make Chinese-made inventions by looking at what is being done everywhere, benchmarking of technology and adapting it to the Chinese landscape. So if you enter the Chinese market, you have an Asian, a Chinese partner, you can be sure that he will follow this strategy. So he will try to understand, digest, absorb, and renovate your innovation. This is in the law. So it has been said it is unfair. Is it really unfair? If you want to do that, this is not illegal. It's just a cultural attitude. It's up to us in Europe, up to us in the West, if we are as patriotic as the Chinese are, while being at the same time open, because Chinese are patriotic, but they are open to the world as well. They need to be in the world. We might also decide to have a strategy, company by company, and why not country by country, that to benchmark what others do and to re-innovate if we can, and then to protect it by IP. So I will stick to that remark just to understand what is the spirit of cooperation and spirit of economy and current economy in the world, even more increased by the current increased competition due to the sanitary crisis, in my opinion. Next slide.
Now, if I may interrupt
sure.
you a little bit, because we received a question regarding previous slides. So maybe before we move to different topics, maybe we could address it. Sure. So basically the question regards this different kinds of patents and the times, the duration, when do you have to apply, for how long do they last? And the question is, what does the examination period mean? Does it mean that the solution will be protected after this examination period? So does it mean, if I understand correctly the question, does it mean that before we apply for the patent, you said that it's 18 months, then there is examination period, and afterwards my solution is protected?
Okay, very, very good question. And that's where it's tricky. I will have a very short answer. One, you can patent only something that is confidential. So at the time you file a patent application, you must have kept your invention confidential, secret. If you ever have published it, or if you have sold it, or if you have shown it somewhere on a fair, or whatever, it's too late. And that applies for patent invention, for UT model, for design patent. So first, you must keep it secret. That's the reason why every European company will first file a European patent and then extend the protection to China or to other countries through a system like the PCT system or the direct filing system. Second, you are protected from the time you file, provided that you are granted. So if this is a utility model, or if it's a design patent, you are protected from the very beginning, except if you are rejected for formal reasons. But there is no examination of the merits for those patents. Once you file, you are protected because your application will be registered. But if it's a patent of invention, the category number one, the strongest tool, you will need to be granted after the examination. And your question is a bit tricky because I must explain that you file, then 18 months after you have a publication, but then you have the examination occurring. So it's different. All these are different steps. So it can take 2 or 3 years until you are granted. But in between, you are protected. But of course, if you are rejected in the end, your protection will not be reconfirmed in some way. But the laws say that during the time there is uncertainty, you may use your right, except if you accept in a contract to say, okay, if I'm not granted, we will cancel everything we've made. But the law says that if you don't say anything, you are protected. For example, if you can have a license agreement before your patent is granted, you collect royalties because they pay you to get access to your technology. If your patent ultimately is not granted, you keep the royalties because during this part, your partner has accepted. So you can guess that in the negotiation, your partner will say, well, it's not yet granted, so I will not pay you fully. I will pay you only part or something. But that's how it works. For understanding this, I think the IP Helpdesk proposes other webinars that go more into details about the strategy, because this is really technicalities. We are speaking of big issues, but this is very interesting question. The most important is that file first. If you file your patent application in the first country, you have 12 months, 1 year to extend the protection in another country. So a French company, a German company will generally file first a French patent application, which is cheaper, and they will have some kind of examination of the value of the patent on the local office, the German office, the French, the Italian, the Dutch. I don't want to restrict any national. Sometimes they will directly file at the European Patent Office. It's more expensive, but if they feel stronger with the patent, they will pay more and they will have a larger protection from the very beginning. And before expiration of the 12 months periods, they will file a foreign application based on the original application. That's how it works.
Okay, thank you very much for addressing that.
And that works as well for Indonesia, for Thailand, and for other countries. So for the ASEAN countries, the top countries where you have activity are those the three you have here on the slide for each type of IP right. I've not mentioned brands and marks because this is not the key issue to touch this morning, but you will see that in terms of marks, Indonesia, then Thailand and Malaysia are the top 3 countries. So if you go in those countries, be careful with your marks and be sure that you protect your brand before you enter the market. But because the Philippines are not on the list of the top 3, doesn't mean that you shouldn't look at either. For design patents, it's Indonesia, Thailand, Singapore, and Malaysia. And for invention patents, Singapore is on the top, but it's not, strangely, is not in the list. I don't know why Veronica you didn't cite that country, but this is very important to look at Singapore because Singapore is a very important country because it is a hub in R&D in ASEAN countries. Even more so, because of the battle between the West and China, Singapore is arriving in between and telling, oh, if you have problems, come to my territory and make R&D there and find patents with me, because I am a good actor, a good country that is having very good relations with China and very good relations with the West. So think at Singapore, because it has a mixed system with a Chinese culture and also some type of a Western culture. And it plays the role Hong Kong used to play before it was, before the handover to China. And then Thailand and then Malaysia. Next slide, I will accelerate a little bit because I think we need to leave some time for questions. Here I have a list of the international treaties ruling IP. You must feel confident when you file IP because all this is ruled by international treaties. And the key treaty dates back to 1883 and still working, still in force, is the Paris Convention Treaty. And that's the one who say that if you file in one country, you have 1 year to file in another, and the date of your second filing will date back to the first filing under certain conditions. That has been ruling for 140 years and still in force. And every country in the world, almost every country, all the countries here are compliant and are members to the Convention of Paris. The Paris Convention, you see, this is column number 2. You have the WIPO, you have the PCT that allows to file international patent applications. And then you have the WTO that is reinforcing the Paris Convention. Everybody knows about the WTO. One of the key treaty, there are 4 treaties in WTO. The key treaty is the TRIPS, and the TRIPS is related to IP. And in copyright, you have the conventions, and in trademarks, you have the Protocol of Madrid, and copyright is Berne and Geneva Conventions. So if you are in those fields, let's look at this, understand what are the interests and the limits of these treaties. You can understand that in 45 minutes, I will not detail each of them. But there is legal issue there, and your own lawyer, in-house or outsourced, should at least have some basic information of that and use a specialized lawyer or patent attorney or IP attorney to help use these treaties in these respective countries. Next slide. Please. There is every year, the European Commission will give some information about what they think of the IP system in different countries. And when the European Union is not happy, they will say it. And then when they are really not happy, they will make 3, how do you say in English, pepper, the pimientos. You know what I mean. So that's really a country where you must be careful. Priority 1 in the EU watch list is China in IP. Priority 2, you have India and Indonesia, but also Russia, Turkey, Ukraine, and Argentina. Priority 3, you have Brazil, Ecuador, Malaysia, the Philippines, and Thailand. So in fact, all the countries you are interested in this morning, the EU says, be careful. It's not an easy place for a European company to go. So be informed. And I will very quickly go to my recommendation, what we should do. But really, you see, until now, I'm telling you 2 things. 1, there is IP activity very strongly in the geographical areas you are targeting, and we are discussing today, especially in China, but also in other countries. Second, there are many traps there, so you need to be careful. If you don't have an IP strategy, don't go there, I'd say. But if you are ambitious, learn about it, and then you can win if you play the game. Next slide. So for example, for Indonesia, in 2018, the most recent are not so relevant because of the sanitary crisis. So I went back to 2019. The EU was very satisfied that Indonesia had become a member of the International Trademark Treaty Madrid Protocol. They had a new trademark law. They were protecting geographical indications. They had new regulations on online infringement and new customs measures against infringement. But the EU was dissatisfied that there was a substantial volume of infringing goods originating from Indonesia that were not properly managed, even though there are new measures and new regulations, practically it doesn't work very well. And the proceedings, judicial report doesn't work well. And there is not enough cooperation between administrations to fight counterfeiting. And the new patent law says that if you file a patent there and if you don't use it, you'll be expelled from your rights, and a local company will be allowed to use your patent rights. And if you are in medical data, which is probably not the case for most of you companies here today, but that is not very well protected. And be careful, your brand will be squatted by actors and you don't have much influence on that. So what we call sources of improvement means that there are issues. So the world is dangerous, everybody knows that, including in Europe, including in Asia, everywhere. But in IP issues, it's relatively dangerous in certain countries, and in Indonesia, the EU Commission says it's priority 2. So it's really some danger. Next slide. Patenting activity in remote sensing. I will spend only 10 seconds on each slide, and then if I have questions, we will get back to it. So next slide. Here is the origin of the patent applications of my 2,500 patent application. I showed you earlier some first statistics with companies having the term remote sensing in their name. Most of them come from China, not most of them. You see, by the way, it's not 2,500, it must be 2,800, because there are at least 2,713 that originate from China, and very few from other parts of the world. Next slide. If you look by country of publication, and be careful when you look at patents, statistics are not easy to interpret because it depends exactly what you are looking at. You know the say that there are 3 types of lies, damned lies, and statistics. And statistics are really dangerous things to handle. Here, by country of publication is the same. It means that not only Chinese companies file predominantly in the world, not predominantly, almost exclusively under the name remote sensing, but they file in China. They don't file in other countries quite a lot. So that's quite puzzling in some way, even though there is a limit to my approach that is not scientific. Again, I fully agree with that, but still, that's really striking. Next slide. If you look at what the technological domain and our database search analysis instrument has the possibility to provide this raw information, you will see that it's in many different fields. So if you are interested in one of these fields, you should look more details. Measurement and computer technology are the top technological domain concerned by the patent applications in my selection. But you will see that it goes from chemistry, biotech, to handling, to engines, to textile, etc. So it touches everywhere. And remote sensing is no wonder can be relevant to many, many sectors. If you have questions on that, I can detail. Next slide. And some examples of the 2,800 different patent families that are there. So there is Beijing remote sensing equipment instrument. On the first line, on the far right, you see that it has been filed last year, September 2020, as a Chinese patent. You will see that there is a classification, CIB, that is the International Patent Classification, and you can search for patents by using this very detailed selection. The title of this invention is at the top, is the first sentence of the slide, is satellite communication phased array antenna beam rapid switching method. So it relates to antenna. By the way, you see that there are 2 patents filed almost simultaneously by the same company. The next one has also a similar, not exactly identical title. Then you have the number 9 is a radiometer for remote sensing in-orbit atmospheric correction. Then you have a pipeline oil spilling path analysis method and device. So that's an industrial application, computer equipment and storage medium, and a more mathematical image processing, I guess, patent. The last one, 11, least square matching method based on adaptive object site element. I have made this selection randomly. I say, if you take the 2,800, you will be bluffed of what you will see. And you will eagerly want to have a look at some of those because they are directly relevant to your activity, most probably. Next slide.
Excuse me, Patrice,
yeah,
just
sure.
one comment from my side.
I'm almost done. By the way, I have only 2 more slides, okay?
Good, good. So let's just wrap up. Thank you very much.
Okay, so case studies and strategy, next slide. So when you are in special remote sensing, you have quite complicated issues. And if there are questions, I can try to address this, although that's not easy, because you will have maybe data produced on a satellite under a certain national law, probably the law of the rocket, except if there is who launched the satellite. This is the by default law normally under international treaty. If not, there is an agreement. So you have a first law, then you have data. Data is a very difficult subject because there is no international treaty, and even in most countries, it's not clear how you protect data. Personal data, everybody knows that it's well protected in Europe, and then Europe has imposed worldwide its standards, including in China, interestingly, and also in some way in the United States, in a lesser extent. But non-personal data, that is what is very interesting here, of course. Most of these data, they are about forest, agriculture, about ocean, about atmosphere, about environment, about whatever, or military or whatever. Most of the data has an uncertain way of being protected. And so there is a very subtle way to try to control data. And GAFAs, for example, or I'd say another example, automotive companies are very well equipped to organize protection of data. Because, for example, now in automotive, you have many data you use. And there are very subtle ways of doing this. If you were with data, that is most likely if you are involved in remote sensing activity, you have to study this and to see how you protect data. And mostly your data will be protected through agreement, through contractual provisions. That is not easy to negotiate, especially if you are an SME. But you should think about that because the data is, of course, the food, the source, the fuel of most of business activities. And then you use this data on Earth in a given country, and the national law will apply. And the small graphic I have on the bottom right part of my slide is trying to explain that if you have sensitive technologies, you should protect them and use them. And we are European, so we prefer European law in Europe. So your sensitive technologies use and work only in Europe, and your IP you file in Europe. If you go to a dangerous country is a country of a different culture. A dangerous country is not dangerous for locals, of course. It's dangerous for foreigners. It's not dangerous because it's dangerous. It's dangerous because you don't know enough about it, because you don't have time to study it. So for those countries, you subcontract technologies, but only non-sensitive technologies. And if you need a cooperation, you use offshore third-party country, like Singapore, I mentioned. You see, I'm giving you a tip that I don't explain very much. It might seem strange to say that, but I have only 45 minutes and I'm already over on my time. So I make it very short. But I say, classify your technologies. Be careful that your sensitive technologies, not only you protect, but you use locally, and you don't use in another country. You subcontract only safe technologies or open technologies, and you use a third-party country that has a more familiar system, a legal system for contracting with companies. I just give you the general scheme. Of course, it must be adapted case by case. And last slide, it's my takeaway recommendations. I have 4. Very easy, very short. 1, if you go in one of those countries, build a strong IP policy. Think about IP first. And 1.1, protect you at home. before you go there, file your patent in your country, and don't file it too late. If you file it after you've sold, after you've shown, after you've disclosed, after you have made a paper, it's too late. After you have made a lecture in a forum, it's too late. So file. And if this technology is not protectable, don't go there because you'll be copied. So early priority filing. So first, have a strategy and file in your country, and then use the international treaties to get extension. 2, pre-analyze. Make business intelligence. Look with whom you will work. What is your market? Market study, IP survey, due diligence, patent mapping. Make something more serious than what I've shown. I've shown you just an approach. In your field, check who is working, who are these people, how much file, how much activity they have, and anticipate that if you meet them, you tell them something, the day after they will file the patent on what you've said. 3, prepare negotiations. Sign non-disclosure agreements, confidentiality agreements, very important. Don't go there before you have filed an NDA, you have signed an NDA, and have a strategy and a roadmap for your negotiation. And then manage your contract and enforce your rights. If you don't use your patent rights, your trademark rights to go after infringers, they will not respect you. It's not about filing, it's about enforcing your rights. So there are strategies there. The system is not that bad, at least for China. For the other countries, it's not as efficient as in China, I'd say. But the Chinese system is much better than everybody thinks, but you should enforce your rights. That's where my 4 takeaway recommendations, and now I'm ready to answer questions, but probably after Mathieu will have a say. I don't know whether you want to say something or whether Veronica should tell her question now. I hand over to you.
Mathieu, feel free, the floor is yours. We're wrapping up.
Thanks a lot, Patrice, for this very interesting presentation. I would like to thank again the organizer PARSEC for having given us the possibility to deliver this training. I will only take a few minutes to present you the services of the Chinese and Southeast Asia IP SME Helpdesk. So, who we are, the China and Southeast Asia IP SME Helpdesk. So, in a nutshell, we provide free of charge first-line confidential assistance on IP protection, management, and enforcement in China and Southeast Asia. What does it mean, first of all, geographically? When we talk about China, it's China, Hong Kong, Macau, and Taiwan. And for Southeast Asia, we're talking about 10 countries: Singapore, Vietnam, Thailand, Indonesia, Malaysia, Philippines, Cambodia, Myanmar, Laos, and Brunei. But as you can imagine, the first 6 countries are the most important for us in terms of activities. Who are the beneficiaries? The beneficiaries are EU SMEs. When we say SMEs, of course, we also speak about we also include the smallest one, the startups, and even the spin-up from the European Union and from associate countries that are participating to the COSME program for SMEs that is financing this helpdesk. So we're talking about SMEs that are working with entities in China and Southeast Asia. We're talking about SMEs that are also already established in the target countries, and SMEs that are still in Europe but interested in doing business and establishing commercial activities in these countries. So, regarding Southeast Asia and the China helpdesk, we are active on both continents. So we have each helpdesk has a team divided between Europe and Southeast Asia. So for the China, between Europe and Beijing, and for the Southeast Asia, between Europe and an office in Vietnam. So what do we offer as free services? First of all, we have an inquiry helpline, which is the most interesting service for you as an individual company. It's a service that allows you to ask us any inquiry about intellectual property in Southeast Asia. So, for example, I have a patent. Registered in Sweden. I'm interested in doing business in Vietnam or in Taiwan, and I'd like to know how I can protect my patent in both countries. You just need to drop us an email. I've let the email of the helplines in the chat, and you will receive the information in 3 working days. It's confidential and free of charge. And we insist on this. We are a first line of assistance on intellectual property, meaning that if the inquiry of a company goes beyond this, we will advise the company to see a lawyer, because as we are free of charge service, we don't replace lawyers. We offer trainings. We deliver trainings like the training we delivered today. We also do webinars. Well, in normal times, out of COVID, we distinguish because most of the trainings we give are physical, but we also deliver trainings that are virtual. Since COVID started, we are only, of course, delivering virtual trainings. We have a website and a blog. We have a website where you can access a lot of information, guides and fact sheets on different type of information related to intellectual property, either according to the type of intellectual property, for example, on patent, on trademarks, on trade secrets, on geographical indication, and so on. But you can also access material per country if you want to know more about intellectual property in Thailand, for example, or intellectual property in China. So, the 2 help desks, China and Southeast Asia, are part of a group of 5 help desks that are financed by the European Commission. The first one is the European IP Helpdesk, which is focused on the European continent, and it has a particularity is that they're not only working with SMEs, but they're also working with the second target group is research centers. Then you have the China IP SME Helpdesk and the Southeast Asia. We also have a help desk for Latin America. So, for example, if you want to know how to protect a patent or a trademark in Brazil, in Argentina, in Chile, in Mexico, in Colombia, and so on. And since December, we have a new kid in town. We have a new help desk for India, specifically for India. All these help desks offer the same services, free of charge, and all these help desks are accessible from one single website. Just to finish, you can see here how to stay connected with us, how to follow us. You see both Twitter accounts, our LinkedIn account, also our Facebook page, and our respective YouTube channels. And again, if you have any question, do not hesitate. It's free of charge, it's confidential. You receive the information in 3 working days. Behind the helpline, there are lawyers. In each team, we have an IP business advisor. So we have a lawyer specialized on intellectual property, and he will send you the information in 3 working days. And you can see below the addresses of both helplines. So that was it from my side. I see that Patrice wants to ask something.
Yeah, I see the question by Sandra Alvarado, to which I guess Veronica wanted to draw my attention. That is in the chat. So there's a question: does the production of algorithms have a different or similar process? So answer is, it's a similar process, but not every algorithm is protectable. On the mathematical algorithms or the mathematical processes, or what we call in Europe the computer-related inventions, with a nice word, they are protected if the data you are managing represent a physical entity. So if it's an abstract entity, it's not protectable. For example, word processing algorithm is not protectable in principle in Europe. It can be in certain under certain countries in the US. It is not protectable in Europe and in most Asian countries. But if it's an image processing algorithm, or sound processing, or a geographical representing data, this represents a physical information and it's protectable. In Europe, we have recently, very recently, a couple of months ago, extended the protection to simulation algorithms. So if you make a simulation of a physical phenomenon, sound, image, or whatever, that's also protectable. So just understand that not every algorithm is protectable, but if you enter into the category of protectable algorithms, it follows the normal path. It's just a process of data computation, and you file a patent application. You may not file a utility model, because you remember a utility model is only for products and not for processes. It is probably not a design patent, even though you might protect it by copyright under certain conditions. I don't have time to explain that, but it's very small and not so interesting protection, because the protection of copyright just protects the shape, the form, the aesthetics of your software and of the related products, but not the computation, not the functionalities. The functionalities are not protected by copyright. So you protect the source code, but it's in most cases it's better not to divulgate the source code rather than try to protect by software. Anyway, it's always useful to protect it as a copyright, because you can protect it without disclosing it, without publishing it. But again, this is the wrong strategy to stick only to a copyright protection. You file an application in which you will disclose the data processing, and then you have an examination. And if you are new and inventive and with an industrial application, you obtain the patent. That was my short response. If there is any more question, please do not hesitate, even though I think we are a little bit late in time. So.
Yes, exactly. I mean, there is still last chance to ask questions to our experts. If there is still anything you would like to clarify, of course, you also have the contact details in the chat, and if not, I'm sure you can easily Google that or get back to PARSEC, and we'll get you in touch with the IP Helpdesk. So please feel free to still ask. In the meantime, I will also draw your attention to the short survey. I mentioned before, you also have the link available in the chat. So you still have a minute to take a look at that. And also, I would like to invite you. Oh, sorry, we have a question. We have a question before I close. Perfect. Thank you, Sebastian, for the question. Can you protect an artificial intelligence technology?
Yes. Yes, but there are, of course, the limits I've mentioned. There are very interesting questions about inventions made by an artificial intelligence machine. Who is the owner of this? But in short, yes, of course. You can imagine why. This is the future of technology. So the answer is yes, but it's not that easy to do it. I think the European Patent Office made some statistics showing that, I don't remember, maybe 10% of the patent application filed had some link with artificial intelligence from now on. So yes.
Okay, thank you very much, Patrice, for addressing that. And yes, as we're closing the webinar, if you still have a question, feel free to type it in. Or follow up with us, of course. So in the meantime, yes, as I was saying, you have a short questionnaire to just let us know if you like the webinar. And of course, I would like to invite you to our follow-up webinar we're organizing next week. In the chat, I'm just sharing with you the registration link. It will be very similar idea. We'll be discussing this time intellectual property protection, but in a different region of the world. And as Mathieu mentioned, there are different IP help desks focusing on different regions. And next week, we'll be focusing on Latin America. So if you're interested, please join us and register. And if there are no other questions or comments for today, I would like to thank you all for joining us. Especially great thanks to Mathieu for helping organizing that, and to Patrice for being our expert today. Thank you very much for joining us and our PARSEC community.
Thanks a lot. Bye, everybody.
Bye-bye.
Thank you very much. Goodbye.